Hello, everyone, and welcome to the podcast from Siam Center Law Group. Today, we'll be discussing the various court dates in criminal cases, what happens on each of these dates, and when the defendant must appear in court. This will help you understand how to prepare properly if you ever find yourself involved in a legal process. Generally speaking, when you're sued in a criminal case, you'll need to appear in court at least 3 times. Let's take a look at the details of each of these court dates and how to prepare for them. First court date, pretrial hearing, plea hearing. The first court date the defendant must attend is the pretrial hearing, also known as the plea hearing. On this date, the court will explain the charges you are facing and ask whether you admit to committing the crime. If you did commit the crime, you can plead guilty, but if you are innocent, you will have the opportunity to fight the charges. The court will also ask whether you have a lawyer. If you already have a lawyer, the court will not appoint one for you. However, if you don't have a lawyer and need one, the court will assign one, unless it's a serious case with a high penalty. Second court date, mediation, protecting rights. The second court date is for mediation or protecting rights, also known as a settlement hearing. The judge will encourage both parties to discuss and try to reach an agreement. Victims will be invited to exercise their rights to claim compensation according to Section 44/1 of the Criminal Procedure Code. If an agreement is reached, the victim can withdraw the complaint or report, which could lead to the charges being dropped or reduced, especially if the case is one that can be settled. In cases where the victim agrees not to pursue imprisonment, there is a good chance the court may decide not to impose a prison sentence. Third court date, evidence examination. The third court date is for the examination of evidence. On this date, the court will check the evidence provided by both parties, including witnesses and documents. Both the prosecution and the defense must submit their evidence and witness lists to the court. The goal is to ensure fairness and transparency during the trial, avoiding any surprises or disadvantages for either side. Both the defendant and the plaintiff must attend unless the case is being judged in absentia, which can happen in cases with a prison sentence of less than 10 years. Fourth court date, witness testimony. On the fourth court date, the prosecution will present its witnesses first, followed by the defendant. It's crucial for the defendant to attend every court session to hear the facts, witness testimonies, and other relevant details that will shape the case. While the defendant may be allowed to skip some sessions with court approval, it's always advisable to attend every hearing to stay fully informed about the case. Fifth court date, judgment hearing. The final court date is the judgment hearing. The defendant must appear in court for this hearing. If the court rules in your favor, you'll be acquitted of the charges. However, if you're found guilty and were previously granted bail, you'll need to continue paying your bail and may appeal the judgment. This concludes the typical process for a criminal case. Understanding each court date and the legal steps involved will help you feel more prepared and confident during the process. In the next episode, we'll talk about how to prepare for fighting a criminal case. Thank you for listening, and see you next time.